Started this morning with an oral argument session, January 12th, 2021, 5th District Court of Appeal. I'm Jay Cohen from Orange County. We've also got on the panel Judge Lambert, Brian Lambert from Marion County, and Judge John Harris from Brevard County. I think it's an excellent panel this morning, but only half of you will eventually agree with that assessment. So we've got a number of cases spread out over the course of the morning. Remember that we are recording this on YouTube. Our audience has swelled almost up to double digits occasionally. And remember that about 6 of those are our law clerks, so I wouldn't get carried away with it. But our first case this morning is State of Florida versus Freddie Parker. That's case number 2673. Ms. Tapman, when you are ready, you may proceed. Now, I do have a default of 5 minutes for rebuttal time, but you can request whatever amount that you want, and we'll be glad to accommodate that.
Thank you. May it please the court, my name is Kaylee Tapman and I'm representing the state of Florida. 5 minutes for rebuttal is fine, thank you.
Fine.
The main issue today is whether after the legalization of medical marijuana and hemp, that the odor of cannabis still creates probable cause to justify the search of a vehicle.
Right, Ms. Tapman, let me ask you this. Then that sounds like the initial contact or the reason for the is a traffic stop. Is that correct? That's what you seem to indicate in your brief.
Correct.
Okay, so we're not talking a consensual encounter here. We're talking whether there was grounds for the officers to stop the vehicle to begin with.
Correct. The officers viewed the defendant parked in the middle of the road. One officer described it as the middle of the road. The other officer described it as 3 feet from the curb. Either way, it was impeding their flow of traffic.
What traffic? What evidence was there that that vehicle impeded any traffic whatsoever?
The officers weren't able to get through. The other justification for the traffic stop was the window tint.
Hang on. Let's go back to that one, because didn't the officers testify that they didn't even try to go through?
They did not try to go through.
Impede? In fact, if you watch the body cam video, you can see a green pickup truck drive right through.
I think
the arrest affidavit, as I recall, says that he was blocking traffic, which was not really borne out by the video or the testimony at the suppression hearing, right?
Well, I believe the body cameras start after the officers have pulled over and parked. The blocking of traffic is not shown on the body cameras. And the other justification for the traffic stop was that the defendant's windows tint was dark. The officers testified that both of them testified that the window tint was pretty dark.
Did they measure it and make any determination that it violated Florida law?
They did not. And the reason that they did not is because when they approached the defendant, they immediately smelled the odor of cannabis. And then when he opened his car door to get his identification, the beginning of pretty much every traffic stop, they smelled the odor of burnt cannabis emanating from his car. And so at that point—
Did you watch the body camera completely?
Yes.
Okay, so at the end of it, you'll notice one officer talking about how he had to persuade the other officer to make one more stop because they would find drugs. Did you pick up on that?
I did not.
Okay.
But
because
I would
really has the feel of pretext is the reason that I am bringing that up.
Well, and my answer to that would be that the subjective intentions and motivations of the officers are not really relevant in a probable cause Fourth Amendment analysis under Wren. So long as there was an objective, reasonable reason for the stop, the subjective motivations of the officers don't really matter. And so they both testified that he was impeding, that he was blocking the road. They both testified that.
That is contradicted by their own body cams. They weren't, this car wasn't impeding traffic. And nor do we have any evidence that the tint was illegal.
The reason that they didn't, I think the reason that they didn't bother testing the tint, though, is that when they made contact with him, the stop for the traffic violations transitioned into a stop to investigate the source of the odor of cannabis.
All right, well, let's go
What if
and
they were
talk about that a bit.
I mean, what if they were completely wrong on the law, that there was no traffic violation for impeding traffic? I mean, the statute says it has to be willful. You have to be willfully set out to impede traffic. So let's just assume that the officers didn't know that. They're wrong on the law. Aren't there cases that then say the stop is per se illegal?
Well,
if they're
not
wrong
only
on the facts, it's fine.
I'm not sure. But I think not only is the impeding traffic, I think it's also the window tint. I think it's the totality of both of those that justify the traffic stop. And even if, and I agree that this was traffic stop, it wasn't necessarily a consensual encounter. Under these facts, that's what they testified that it was, because they asked him for his identification. But they walked up to him and they immediately smelled the odor of cannabis emanating from his person.
Well, as to the stop, I mean, it's not whether they actually violated the traffic laws, it's whether there was probable cause for them to believe that there was a violation of the traffic law.
Correct. And
So, and I'm not sure about the blockage, because if I read the one statute, 316.2045, that seems to be talking about a pedestrian blocking as opposed to a vehicle blocking, because it's a pedestrian violation if you violate subsection 1. But they did talk about the tint, and the fact that they didn't measure the tint, I don't know that that's dispositive here. It seems the issue is the judge just decided it was pretextual instead of deciding whether there was in fact probable cause, because if there was no probable cause, then it shouldn't be a stop, and then all the rest of our discussion seems to be irrelevant. Do you agree? I mean, if there's no basis for no probable cause for the traffic stop, then we don't even get to the odor of marijuana issue, don't we?
yes, I agree with that. Mostly just because it was the basis of the traffic stop that they asked him for his identification, and that's what prompted the rest of the
Well,
conduct.
let me ask you this: under the medical marijuana statute, as of March 18, 2019, it looks like you can have smokable marijuana. Are you allowed to smoke medical marijuana in the car?
No, unless it's a low THC. You cannot smoke in a car unless it's in a low THC form. But I'm not sure whether that still even applies to the driver, because it also talks about, passengers can't be smoking in the vehicle. I wasn't really, either way, I agree. You can't really smoke medical marijuana in a car. I don't know whether.
Could you smoke hemp in a car?
I don't know whether people smoke hemp in general.
Well, people do smoke hemp.
Okay. I don't know, but I also believe that the totality of the circumstances under this set of facts led the officers to have probable cause to believe that the odor they were smelling was unlawful contraband. And
Well, hang on a second there, because that's where I have another concern. They had reasonable suspicion that Mr. Parker was in possession of cannabis, but don't they have to have reasonable suspicion that he was unlawfully in possession of cannabis?
yes,
Where does
and
that come in?
I believe that they do, because if you consider the odor along with the other totality of the circumstances surrounding what was going on, that gave the officers the probable cause to believe that what they were smelling was contraband. And those circumstances were, they viewed the defendant parked in the road, talking to a bicyclist in an area that both officers had personally investigated for narcotic street sales. Then when they approached the defendant, he became extremely nervous, saying, "You got me, you got me." And those facts are what led the officers to believe that the odor they were smelling was unlawful contraband, which justified the search of the vehicle.
Could these officers distinguish between the smell of burnt cannabis and the smell of hemp or raw cannabis?
No, they could not. I don't know that there is a distinguishable difference that they could have otherwise been trained on. It's not that they weren't trained.
Were they asked? I mean, I know that I think like they were asked burnt hemp, burnt cannabis. Were they asked the difference between burnt cannabis and just non-burnt cannabis, for lack of a better term?
Yes, raw, yes. They were. Deputy Pinos did testify that he could identify the difference, and Deputy Ritos said the same and described the difference at the suppression hearing.
So if there's no burnt cannabis, if it's simply this fellow, Mr. Parker, had raw cannabis there, no smell of the burnt cannabis, then your scenario would be problematic, wouldn't it?
I think it would be more problematic. I don't know that that would be entirely dispositive, but in this scenario, it was burnt.
Well, why wouldn't it be dispositive? Yeah, why wouldn't it be dispositive? If I'm not smoking cannabis in the car, you can have a certain amount of cannabis or marijuana is permissible now under the Florida statutes, and I have it there. Let's put it in plain view, make it even easier. What am I doing wrong that now gives you the reason? Maybe wrong is not the right legal term, but what am I doing to give you the reason now as an officer to search my vehicle simply because I smell like I smoked dope at some point?
In this set of circumstances, I agree that you could not. I'm sure that we could come up with a hypothetical in which, that would still be based on other facts, that it would still be justify a search.
But here we have the smell of the odor of the marijuana, and you're saying you can't smoke even medical marijuana in a car. So that gives them some suspicion that, okay, there's something amiss here. I'm not using very good legal terms this morning, but there's something amiss here. So we are going to search under like the old days where before there was the medical marijuana, where that gave probable cause to search a vehicle for contraband or other evidence of a crime.
Correct. And that's because
your argument here, is that where we're going?
Yes, and it's because the probable cause standard is a practical common sense standard. The officers are not required to rule out every possibility of innocent behavior. And
let me ask this, Mr. Tavern. Is that argument impacted by the number of people relative to the population that have prescriptions for medical marijuana?
I think this becomes a harder argument the more marijuana becomes prevalent in Florida.
If it's legal, what if it's legalized?
Yeah. Excuse me?
What if it is legalized?
I think this turns into a different argument that I think it becomes a harder question. I think that there would still be facts. For example, in Colorado, where marijuana is fully legal, they still consider the odor of cannabis in a totality of the circumstances argument, along with other factors.
I mean, if it's legal and people could smoke it, but if they're smoking to the point they're impaired, then
correct,
I give them some reason. But I mean, if there's no suggestion that this fellow, Mr. Parker, was impaired, and he doesn't look impaired in the video, and the officers don't say he's impaired. So you don't have that as the other circumstance, the odor plus kind of argument here, right?
Correct. There was no evidence that he was impaired, but they did just, Deputy Pino testified that the inside of his car and defendant himself smelled as though he had just finished smoking, and they did, watch him leave his vehicle. Other than that, there was no testimony that the defendant himself was acting impaired.
If they smelled it on him, but there was no odor in the car somehow, let's go fantasy land. There's no odor in the car here. They wouldn't then have right to search at that point, would they?
No, I don't think they could search the car at that point.
Right.
No.
I'd like to go back to my question to you about the number of people that have prescriptions for medical marijuana. Assuming that it's a small percentage, would that make a difference? Does it make a difference as to the percentages of the total population that have prescriptions? If it's a a relatively small percentage of the population? Would that make a difference?
I think the fact that there is, I believe, a relatively small percentage, because it makes it more likely than not that the odor that the officers were smelling was unlawful contraband.
All right, so let's take that and use this hypothetical. Let's assume, for the sake of discussion, that 20% of the Florida population have permits for concealed firearms. And the law enforcement, come up upon, a suspect, and they see what appears to be a concealed firearm, but they don't know whether he has a permit or not, but they know that only 20% of the population have permits. Does he have probable cause at that point to take further action?
He does not, based on the case law as it currently stands. And I think the distinguishing factor between firearms.
You're assuming that case law is decided correctly, and I want an analysis of that and then apply that to this scenario.
I think the main difference between that scenario and the cannabis scenario is that carrying and possessing a firearm is a constitutional right under both the federal and the Florida Constitution.
Concealed?
And so I think
concealed, is it under the Florida under the Constitution? Is it can you carry it concealed?
no, you cannot carry concealed. But I think that because of the right to possess firearm, it's in a different class. It has its own kind of protection of it. And, there are certainly circumstances where you can't possess a firearm. If you're a felon, you're underage, you're carrying it concealed illegally. But I think that firearms are in a constitutionally protected class in and of themselves. And in contrast, cannabis just doesn't have that same kind of protection.
All right. So the percentage of population wouldn't impact anything in your view of on the firearm, but it would on cannabis?
It's not the actual percentage. It's more the likelihood, I think.
Well, we're talking about probabilities. We're talking about probable cause.
Sure.
Right?
Yes, Your Honor. And I'm not sure. I'm not sure.
Okay.
Distinguishing the defendant's pill cases, I think it also comes down to a similar kind of discussion where, pills themselves of controlled substances, those kinds of cases, pills themselves are ubiquitous in our society. They could be anything, vitamin, aspirin, cold medicine. And then once you get to the controlled substances, you can still carry it with a valid medical prescription. And so in most scenarios, I think that, in everyday terms, pills are legal. And in contrast, there are only limited circumstances where you can carry lawful contraband. I would like to reserve the remainder of my time for rebuttal, please.
All right. Thank you, Ms. Tapman.
Thank you.
Thank you, Your Honors. May it please the court.
Can you move closer to the microphone?
Yeah, why don't you have a seat and just relax? Yeah, we can't. It's hard to hear you when you're that far away. So just relax.
Yes, Your Honor. I apologize.
You don't need to apologize. It's a very nice jacket you got on.
Thank you, sir.
Where'd you go?
Okay.
Okay, there you go.
Better for everybody?
It is.
Better.
Okay, excellent. Thank you very much. Your Honor, if I could just jump right in, I'd like to first point out that I think the state's argument here makes two main mistakes. The first is that it mistakes a sufficient condition for a necessary condition regarding the odor of cannabis, which I think Your Honors have picked up very well in your focus on the pill case as well as the Kilburn firearm case.
Are you saying that we sniffed it out?
I believe that we are all on the same page at this point, so I appreciate that. The second,
I wouldn't go that far yet.
Yeah, be careful what you believe.
Yeah.
Yes, Your Honor, understood.
Tailor your argument to think that we don't believe you or don't agree. So convince us.
I only assume that no one agrees with me at all times, so that's.
I know you don't have the burden here, but go ahead.
Are you married?
I am not currently married, no, Your Honor. I do have a girlfriend though. She's in the room next door.
All right.
So the other main mistake that the state makes here, I believe, is they've confused apples for oranges and calling the trial court's ruling invalidating the stop because it was, quote, pretextual, as if this was a ruling that came down before the Wren rule and Holland's adoption of it in Florida. Actually, what the trial court's reference to a quote unquote pretext was intended to do was to signal that she had not found law enforcement credibility in this case. She did not
That's
find
not what she said, though.
testimony.
She didn't
I'm
say, I don't find that there's probable cause for the stop. She said it's pretextual, which is the wrong analysis, don't you? Apparently you agree with that. It's pre-Wren, that was fine. Post-Wren, it's an objective, not a subjective standard, right?
Yes, Your Honor, that is 100% correct. And I believe actually that the trial court got that right here. Now, I know they did use the term pretext. However, immediately after using that term, they go into explaining under the totality of the circumstances analysis, the search is still not rehabilitated. I believe that she found...
Reasonabilitated? What's that?
I'm sorry, Your Honor. If this was an invalid traffic stop, the idea being that the smell of marijuana did not make the stop good at that point is an independent source of problem.
Well, I mean, she says, I mean, when her ruling is law enforcement testified they approached him because he had a tinted window, yet the video was clear that they asked him for his identification. I don't know why that's in this disjunctive. I mean, you're certainly permitted under our case law to ask for ID if you think that somebody has committed a traffic violation. You agree with that?
Yes, Your Honor. I 100% agree with
then
that.
She goes on and says they opened the door and they refused to allow him to close it because they, according to them, they smelled the odor of marijuana coming from the door out of the car. So they're permitted to do that too. Don't you agree? Assuming the traffic stop is valid, and before we get into your other argument, under the old days, that would be fine, right?
Yes, Your Honor. And I think that this case follows exactly what the standard protocol is for law enforcement involving the odor of cannabis stops.
I mean, your view, basically, as I understand it, is it's a new day because of the medical marijuana law. And if I'm gleaning this, your best argument is hemp and marijuana smell the same. Therefore, if there's any odor that may be hemp or marijuana, you can't tell. Therefore, any basis to do a search on that is invalid. Isn't that your position?
Well, I think that gets at an important part, Your Honor, but I don't think it fully captures our position. And the reason being is because the chemical differentiation between hemp or illicit controlled marijuana or medical marijuana, low THC or high THC, there's 5 different ways that you can possess cannabis in the state of Florida under 893.02 subsection 3.
But you don't need to, if you're an officer, you don't need to know precisely that is contraband at the time you're doing the search. There's a case that we wrote last year, very good author wrote, called Thornton versus State v. Thornton, about that. And the officer doesn't need to know exactly, but I mean, it certainly he has probable cause to believe it might be unlawful marijuana. And at that point, if it turns out that it's not, I mean, that doesn't summarily mean that the search is invalid, does it?
Your Honor, I think the problem here is there's no other factors that were found by the trial court or that could be found, I believe, by the appellate court that could indicate any way whether or not the smell of cannabis that was detected this day was illicit or lawfully possessed cannabis.
You can't smoke medical marijuana in a car, correct?
I believe that's true, Judge Cohen. However, I also believe that under the hemp statute, there's absolutely no prohibition on where, when, how, or why you possess or use hemp. It's an agricultural commodity. And as far as I can tell from that statute, the only limitation on the use of hemp involves licensed cultivators of it, people who are growing the substance.
Right. I mean, so there's certainly indicia here that there was some substance smoked in the vehicle because of the odor. So that old days, that would have given them probable cause. And again, getting back to what I think your argument is you can't tell if it's hemp or marijuana. Therefore, any search of the vehicle based upon that smell is invalid now under the medical marijuana, under the statutes.
Well, Your Honor, I think it's more than just hemp or illicit marijuana. I think it can be more than that. However, with the odor from the vehicle itself, assuming that it is a burnt smell coming from the vehicle, then yes, I would agree that's correct. I think first I would like to say that I think the easiest way for your honors to avoid getting to the odor of cannabis issue in this case is uphold the trial court's ruling as saying that there was no factual basis for a traffic stop in this case, and they were never exposed to the odor of cannabis prior to the improper seizure. And the seizure was affected by way of show of authority and the submission to that show of authority by Mr. Parker when he exited the vehicle and walked back there to talk to.
I mean, let's say that let's say the tint was unlawful. Let's say that. I mean, I know it wasn't tested. I know there was no ticket. I don't think it's dispositive. You don't give a ticket, because that's like saying, well, I'm stopping you for rolling through the stop sign, and I don't write you a traffic ticket because I see there's a dead body in the back of the car when you go get it. I mean, that doesn't matter to me that there's no ticket, frankly. All right, so let's say there is probable cause that there's a tint violation. At that point, watching the video, there doesn't seem to be anything that the officer did wrong to follow this fella, Mr. Parker. He's going to his car to get his ID because he's permitted to get the ID, to look at the ID, right?
Your Honor, assuming that the traffic stop for window tint was good.
I'm assuming the traffic stop's okay. So let's go to my question.
Yes, Your Honor. Assuming that, then yes, I think it was proper for them to ask for the identification. However, as the trial court found, when they refused to let Mr. Parker close that door, it then became a seizure based solely on the, or rather an arrest was found by the trial court based solely on the smell of marijuana from the car.
I mean, they didn't put him under arrest. They certainly detained him, whether he was arrested at that time. But I mean, you're saying we could decide this case without getting to the odor issue. I'm saying I don't necessarily agree with that position you're taking. I mean, because I think the judge did determine it was pretextual based upon what the fellows were saying the officers were saying on the video. In essence, that, they were trying to make a drug stop here. And and they're saying that's pretextual. And then under the old case law pre-Wren, it couldn't, But now if there's an objective basis, the reason that they're stopping them because they really want to get the drug guy, it doesn't matter, as I understand under Wren. It still then has to be a determination, is there probable cause? Which
yes, Your Honor, that
the judge went off, didn't say that. The judge says it's pretextual, which, to me is red flag pre-Wren. And that's an improper analysis. That doesn't mean you couldn't go back and say, okay, now that I've been given better direction from the appellate court, I find there's no probable cause for the stop. That'd be a different ball game here, to me at least. But that's not what's coming out of her mouth, and that certainly is not what she wrote in her order.
I understand Your Honor's position 100%. I do know that Judge Adams used the term pretext in describing the basis that law enforcement provided for the traffic stop. I think specifically she was referring to the obstruction allegation, which is pretty ridiculous when you watch the body cam. If anyone could have been charged even with that traffic violation, it would have been the biker. The biker was the one between the roadway and anyone trying to affect an egress. And as Judge Harris rightly noted, there is a green truck passing at the very start of the body cam.
Mr. Lightfoot, let me get to the odor issue a little bit. The one officer testified that he was able to discern the difference between raw, marijuana, and I think hemp would fall within that classification, and the odor of burnt marijuana. Why isn't that a valid distinction? Why isn't that determination supported by the evidence?
Your Honor, I think the fact that half burnt blunt was found inside the vehicle is definitely confirmation. It seems like that there was probably a smell at least inside of the vehicle. However, I think that the distinction between burnt and raw cannabis here was found by the judge to be not credible. And the reason why I say that is because, first of all, Deputy Pino had written in his police report that he had smelled the, quote, freshly burnt cannabis cigarette. The freshly burnt terminology basically covers both of his bases. Fresh is usually a term used for raw, burnt obviously goes to the way that the cannabis was used. And he seemed to be covering both his bases. And I think that the trial judge found exactly that. Now, regarding Deputy Rios, who I think spelled out the distinction more clearly that you're talking about, I think Deputy Pino simply said, yes, I can tell the difference. But Deputy Rios said that the burnt smell is very heavy. It's distinguishable. The raw smell, however, is, quote, a sweet smell. And he said that within one breath, he said that he smelled burnt and unburnt cannabis inside of the vehicle. He wasn't sure what he had smelled. It makes more sense based on the blunt having been found to say, oh, it was a burnt smell that I smelled. Later on cross-examination, I asked him about the sweet smell that he had smelled during that encounter, and he conceded it was a sweet smell that he had smelled, and he couldn't tell the difference between that sweet smell if it was hemp or if it was illicit cannabis.
One could and one couldn't. But there certainly appeared to be substantiated by the finding of the half smoked blunt in the vehicle that was an accurate understanding.
Yes, Your Honor, I think that's correct. And I think that the smell from the vehicle, it's really not something that is contestable at this point. However, I do think
Right, what does that mean? That means that you concede that there was the smell of burnt marijuana in the vehicle?
No, Your Honor, it is invisible to smell. And that's one of the most pernicious things about this as a source of probable cause. And one reason why the credibility determination is so important in this case. The appellate court here does not have the same vantage point.
Yeah, but what she said, what the judge says is, okay, they apparently did not intend to give him a ticket for the tint, so that's just a pretext they used to stop him. So that's an incorrect analysis. And then she says, I further finding that the smelling marijuana is not probable cause to search the car. So she concedes that there's a smell of marijuana in the car. She finds that. They were going to stop him to give him a ticket for his tint. They didn't do that, and there would be no reason to arrest him for smelling marijuana. I mean, she seems to be not following the process of what, certainly they're not arresting him for the smell of marijuana. That's giving them, they arrest him for finding the cocaine. They smell the marijuana in the car, so that gives them probable cause in their view to search, and that's where they find it. So, I mean, her analysis as to why the motion's granted seems to me to be wrong on every level as she goes through there. Now, whether she got it right, I mean, you're kind of saying, okay, look, however we get to the point, hemp and burnt marijuana smell the same. You can smoke hemp, so it doesn't give grounds to search. And if there's no grounds to search based on odor, if it's just odor alone, that seems to be what you're arguing. And that is kind of one of the critical questions that we're being asked to decide. But I mean, I'm just reading what she says. And it doesn't seem to be correct. Well, I'll put it politely.
Yes, Your Honor, and I understand your concerns with the reasoning of the court below. I think my interpretation of what the ruling actually is saying is that the traffic stop was not founded by probable cause based on problems with credibility of law enforcement. Even if the traffic stop was good, it would still not be a good stop based on the exposure to the odor of cannabis down the road. I think that very important to her ruling here was the claim that Mr. Parker was acting nervous. I think that this was a very big deal for her. Deputy Pino downplayed the fact that there's a neighborhood party going on right across the street. There's kids running around. I mean, everybody's watching what's going on.
She doesn't say that when she's saying, I find that the officers lack credibility about basing it out on the nervousness, et cetera, et cetera. She doesn't say any of that when she says, okay, here's my ruling. Here's how I get to point A from point A to point B. I mean, you're kind of, and I get it. You're defending your client. I get all that, but I mean, that's not what she says. And so I'm looking at what she says as to how she gets there. And it seems she's not really following the Fourth Amendment analysis here. That
Well,
should
Your
be
Honor, I think
applied.
she does eventually turn to the totality of circumstances verbiage, and that may be more palatable. I totally understand the point being drawn by Your Honor.
What she says is based on the totality of the circumstances, there's no reason to search the car. I mean, I don't, you know, if you can't smoke medical marijuana, there's no evidence of any hemp in there. It's an odor that ostensibly gives you probable cause to search, because I think we've all conceded you cannot smoke medical marijuana in a car, and therefore it's a violation. Okay, what?
Well, Your Honor, I think analogously, we would say, following that logic, if I saw a pill in your center console, and there's no evidence that it's Tylenol, well, then I can seize it, right? I mean, I think that it's codeine, so I can seize it.
Well, no, because there's no evidence that if it's just there, it's a lawful substance that I have there at the time. And I mean, to me, it's a big difference if it's just raw marijuana, raw medical marijuana, then it's just sitting there, and that's not a basis, I don't believe, to do a search. If there's no odor, it's just raw. I mean, I think the odor becomes the problematic thing. And it seems you're saying is that odor at all does not give any basis for probable cause at all anymore under Florida law, present Florida law. Is that what you're saying?
I think that the owner of cannabis can be considered under a totality analysis. I think that would be proper under the law today. However, I don't think that in this particular case, there were any facts and circumstances that could indicate one way or another the criminality of that smell that was detected. Just as you're saying about the pill in your car, it's a lawful substance that you possess. Well, someone who's using hemp in their car would say the same thing. I mean, the logic would be equally applicable there. And so the problem here, I think, is that we're trying to treat cannabis like it's an orange, and every other type of plain view item that could possibly indicate criminality as an apple. And I don't think that under the Constitution that's permissible. There's nothing that distinguishes the plant cannabis from a firearm or pills or a pipe that could be for tobacco or could be for cannabis consumption. I think the pipe case and the ML case is one of the best ones for us because of just how simplistic the probability there is of criminality. It's 50-50. It's either for tobacco or something else, or it's for illicit cannabis. And that's just not enough to seize it. So here the analogy would be, well, there are no other facts or circumstances to indicate that this is ongoing crime. And the reason for that is because the trial court found that law enforcement claims to nervousness were not credible. If anything, Mr. Parker was exhibiting frustration at being pulled over for what he felt was no reason in front of neighbors, friends, family. Just a very humiliating scene for him. And I think that Judge Adams did get it right here. And we would submit under a tipsy coachman analysis that she did get it right. And we would ask that the court follow Scalia, his dissent in Ornelas, urging that appellate courts give ample deference to trial courts in terms of credibility determinations, even in the face of uncontroverted law enforcement testimony like we had in this case. Thank you.
Mr. Lightfoot, I'm going to give give you a little extra time. I'll give Ms. Tapman a little extra time as well. I just want to very briefly go back to the initial contact. When your client was at the side of the road, had the police stopped him? When he's initially,
that's a very interesting question. So I believe that at different moments, different statuses
let's talk.
are
When they
present.
first see him with the bicyclist, have the police stopped him?
No, I don't believe so.
Okay. When the police exit their car, he moves his car forward. Was that at the direction of law enforcement?
Not any express direction. No.
Okay. And then what does then he stops his car and he gets out of the car, correct?
He exits the vehicle, correct?
All right. Have the police stopped the vehicle at that point?
I am not sure, to be honest, Your Honor. The both deputies testified the fact that they didn't have to use their lights and sirens to effect a traffic stop.
But they hadn't directed him to stop. He goes over, he moves the car, he gets out of the car. None of that at the direction of law enforcement, correct?
That is correct, Your Honor.
They
I think
come
that
up
the
and they ask him for ID. Is your position that the asking of him for ID converted that into a stop?
Your Honor, I'm not sure that ID was requested or whether it was ordered in this case.
But regardless, I mean, let me see your ID. Whether they ordered it or asked politely, would you mind showing us, or let me see your ID? Did that convert that into a traffic stop?
I believe that the officers testified to believing this was a traffic stop.
I'm not asking what they believe, just like, we don't really care, subjectively what they, what they thought. I'm asking you legally, did that convert it into a traffic stop?
Your Honor, I believe that the facts here do fit a traffic stop.
Okay. All right. Okay. Then thank you for your argument. And Ms. Tapman, I'll give you an extra couple minutes as well.
Thank you.
Thank you.
Thank you, Your Honor.
Start up where we left off. Does the fact that they asked him for ID convert this into a traffic stop?
I think under these facts, it does.
Why?
Because it was I think in a consensual encounter, you can ask, they don't have to give it to you. But they wanted to see his ID because they were conducting a traffic stop. That's the beginning of traffic stops. And so at that point, I agree that up to that point, it could have been a consensual encounter. They did not direct him to get out of the car. He parked on his own. They even testified that he wasn't even, that was all on his own. And so I think it was the point that that the officers asked for ID where it truly became a traffic stop.
Well, why doesn't that simply convert it from a consensual encounter into some sort of detention as opposed to terming it a traffic stop?
I don't know that it doesn't. I'm not sure where you're going. I don't see how that changes the equation in this case. Just that, the state's position is that the officers acted legally through each step, and that the totality of circumstances led them to believe that the odor they were smelling was contraband. I would like to note that the trial court never explicitly made any credibility findings. And I would also like to note that
let me ask you this, Ms. Tapman, while you're on that point. It seems like in the majority of these suppression appeals, we're talking about the denial of a motion, and the state's arguing, the deference that we need to give the trial court's findings. Well, now the tables are somewhat turned, so let me ask you that. There's a presumption of correctness to the court's findings, right? And to the inferences that come from those findings. What about the court's specific finding here that these guys were going to make this arrest regardless, and there was no probable cause? I mean, I think that's exactly what she says. It was a stop they were intending to make. It was not based on any probable cause of a crime occurring. Is there competent evidence to support that finding, including, as Judge Cohen mentioned earlier, the officer's statement at the end that, I told you if we stopped one more car, we'd find drugs or something like that? Doesn't that support her finding that there was no probable cause and they were stopping this guy regardless?
I think that the finding of probable cause is a legal finding, not a factual finding, and legal findings should be reviewed de novo. And I also would like to just mention that, as Judge Lambert was pointing out, her factual findings and her legal findings don't necessarily flow from one to the other. And her analysis as to whether the stop was pretextual is no longer a valid legal analysis after Wren. Prior to the changes in laws, it was very clear in the state that the odor of cannabis justified the search of a vehicle. This court's case in Reed, the Supreme Court case in Betts, And the only case regarding this currently is Johnson out of the first. Admittedly, it was decided before medical marijuana was smokable and before the legalization of hemp, but I think its reasoning stands. And it noted that the possibility of the odor being from medical marijuana did not negate the probable cause determination. And so we ask that you reverse. Thank you.
Right, certainly though, you can see that, if marijuana, if cannabis is legalized, you're gone on these types of cases, correct?
I would say that the state at this point is not prepared to make that concession, but I would agree with you that it would be a much harder case to make.
Well, make any case.
I think, if you see it's recreational, but chances are when it becomes legal, you still can't have a kilo of marijuana in your car. I imagine that you still won't be able to smoke it while driving. I think there would still be scenarios.
Hold on, can you consume alcohol and drive?
Not while you're physically driving.
That wasn't my question. Yeah, not when you're physically driving. I can't have a glass of wine and drive.
I believe that would violate an open container law.
Oh no, I didn't. I had a drink, and I got behind the wheel.
Oh, and then drove. Yes, I agree that you can do that. I meant you cannot smoke and drive at the same time. And so when it's emanating from your person, I think that, but coming from a burnt smell from the vehicle as though someone was smoking in the vehicle and driving, I think that would create a situation.
When you have to establish impairment?
I don't know. I think these are questions for further down the road.
Well, these are hypotheticals that we're asking to examine your position in this case.
Yes. I don't know that you would need to establish impairment based on how the other factors that are presented. Impairment could be one of those factors. There may be other factors as well.
Okay. All right. Listen, thank you both for your argument. These are interesting issues that I think we're going to see, more and more of. We've had a couple of these at the court already, and I think that some guidance is appropriate. They're difficult issues, and you both did a very nice job of presenting your cases. So thank you very much.
Thank you.